When it comes to the durable power of attorney, we actually can customize even less. And I said before, this is kind of cookie cutter. These are the most commonly selected provisions we found with clients that we've done these documents for in the past. So the only thing you can customize in the power of attorney is your attorney in fact's name, who your attorney in fact is. Now, the attorney in fact, what that term means is that's the person who kind of stands in your shoes and can act on your behalf. And under this power of attorney is a broad range of subject matter that this attorney in fact can act on your behalf concerning. This is a durable, springing general power of attorney. So general means it's a broad power of attorney. Ideally, it means anything that you could do for yourself legally, this person can do for you. Durable means that even if you become incapacitated, it remains in effect. Ordinarily, a power of attorney, once you are physically incapacitated and unable to revoke your power of attorney, the law steps in and revokes it for you, because I presume the intention is to prevent a person who's given a power of attorney from being taken advantage of if he becomes incapable of stopping his attorney in fact from continuing to act on his behalf. The law steps in and just says it terminates the power of attorney. A durable power of attorney survives the incapacity of the maker of that power of attorney. So because the whole point here is if you get sick or you get hurt, you want somebody to be able to manage your affairs, we make a durable power of attorney. However, we also make it a springing, durable general power of attorney. And the springing means it doesn't go into effect when you sign it. It becomes effective when you become incapacitated. So go ahead and generate this document now, you sign it now, and it becomes useful. It gives power to that attorney in fact if and only if you become incapacitated. And then it remains in effect so long as you remain incapacitated. So in these durable power of attorneys, if you are filling this out as a married couple, it is going to make the spouse, each spouse is going to be the first choice attorney in fact for the other. So this is a great document to have if one spouse manages the financial affairs for the family and the other spouse isn't necessarily on every bank account or every investment account or title on every piece of property. And if the spouse who manages the financial life of the family becomes incapacitated, it might be difficult for the other spouse to manage those accounts without having this power of attorney. So the spouse becomes the primary attorney in fact. Each spouse can also designate who their backup choice would be. And that would be the person who would step in if the other spouse is just not capable of taking care of those affairs. The other spouse might be incapacitated as well. The other spouse might have passed away in the meantime. Do this document now, like I said, it doesn't go into effect unless and until you become incapacitated. So it's possible that before this document goes into effect, your spouse could pass away and not be available to act in that capacity. So each spouse will be able to fill out a backup attorney in fact. And then the Advance Directive for Healthcare, the next section down. The Advance Directive for Healthcare basically lets you do two things. First, it lets you identify a healthcare agent. And that healthcare agent is the person who can make decisions on your behalf if you ever become incapacitated and you're unable to express your own wishes with respect to your healthcare. Now, just like the power of attorney, the way we have this set up, the Advance Directive for Healthcare is by default going to make spouses the healthcare agent for each other. Each spouse, again, can designate a backup healthcare agent. If you're filling this out as an individual, a non-married individual, you designate your primary healthcare agent and your backup healthcare agent. And each spouse or each individual gets this box in which to type preferences and instructions and guidance that will help guide both the healthcare providers and the healthcare agent in deciding how to manage care for this person if this person is no longer able to express their own wishes. And that's the extent of the customization for the documents. So the one last thing we need to look at is the witness section. And you'll notice that there's a little asterisk next to most of the boxes on this questionnaire. Anything with an asterisk next to it is required in order to save. I want you to understand that you don't have to do this questionnaire in one sitting. If you get to this point and you realize, I don't know who can witness these documents for me. A witness needs to be competent to witness a document, but they also need to be available. They need to be willing to do it. You know, in this age of social distancing, it might be difficult to find a couple of people who are willing to get together with you and, you know, go in front of a notary and witness these documents. So if you get to this point and you need to just save it and come back, just put any text into these fields and hit save, and we won't be generating the documents until you specifically tell us below that you're ready to generate those documents. So the witnesses can be anybody who's over the age of 14 and competent to witness your signature. If it is somebody who is a beneficiary of your will, that would not be a good witness, simply because any gift to that beneficiary would be void because that beneficiary was witnessing your will. So we'll talk about signatures more in another video. But a neighbor who you trust, understand that these neighbors or these witnesses do not need to know the contents of these documents. They don't need to read the documents. You don't need to share anything private with them. All they're doing is witnessing that you actually signed the document like you say you did. And once you've gotten beyond that, you come down to this review and confirm section. Again, if you're filling this out as a married couple, there will be 2 sections or 2 drop downs for you to certify that the information is correct. And when you are finished, the last thing you'll do before we generate the documents is you will check that, yes, I'm ready for my no frills basic estate plan. When you do that, then you hit save, and this will show up on a report for us to generate those documents for you and send you notification that those documents have been generated. And that's the whole questionnaire. If you have any questions about what goes into this, please email us at estateplan@piedmontinjurylaw.com. We're probably not going to answer every email individually, but what we'll do is compile frequently asked questions and put up additional videos or additional resources and send them out to everybody so that you can all get answers to everybody's questions. And the last thing on this page, we are doing this free of charge. There's absolutely no fee associated with our generating this estate plan for you. However, these are difficult times for a lot of people. And if you feel like you'd like to pay it forward, what we've done for you here, pay it forward to somebody else, we suggest Must Ministries. They're a great group. We work with them a lot. And if you're interested in paying this forward, there's a link here to visit Must Ministries donation page and help them feed and clothe and shelter the members of our community who, during these very difficult economic times, are having increasing difficulty doing it themselves. So that's the questionnaire section. When you're finished with everything, you've got the witnesses identified, everything's filled out the way that you want it. You check this, yes, I'm ready for my no frills basic estate plan, and you click save the final time, and that's going to trigger the work that we're going to do on our end. And the next video I'm going to shoot is going to show you what you'll see when the documents are ready for you to review and download.